All right, we've alluded to it several times up to now. Let's talk about agency authority, agent authority. When will a person have the power to bind the corporation, right? That person would be the agent and the corporation would be the principal. Who has the power to represent the corporation in transactions with third parties? That's effectively what we're asking. Who has the power to bind the corporation? So the answer is a person can bind the corporation if the person has agency authority, right? Generally, we would say an agent can bind the principal if the agent had authority to do so. So now the question is, what type of agency authority is there? How does this agent get authority? There are three basic types of agency authority. Number one, express authority. Two, implied authority. And three, apparent authority. Let's talk about these in turn. First, let's talk about express authority. This is where the principal expressly gave the agent the authority. Now, express means by words, so it's either oral or written. So here are some examples of how this can happen. A power of attorney. Have you ever heard of a power of attorney? Power of attorney is just where one person gives the power to another person, the agent, to bind her, to act on her behalf. Now, you might have also heard of the term attorney in fact. You guys are in law school so that you will become an attorney at law. That's a different thing. An attorney in fact just means that you have agency authority, that you have the power to bind a principal. A board resolution. A board resolution can say, we give express authority to this person to bind us in this transaction. That is express authority. Let's talk about implied authority. So if you don't have express authority, maybe you have implied authority. Or let's say it this way, if the agent doesn't have express authority to bind the corporation, to bind the principal, then the agent might have implied authority to bind the principal. The test for implied authority is, did the agent reasonably believe that she had the authority to bind the principal based on some conduct of the principal, right? So this focuses on the reasonable belief of the agent. Now, even though it focuses on the reasonable belief of the agent, the third party will use this argument. So if the third party dealt with the agent and the agent dealing with the third party bound the corporation to a contract, right? And now the corporation is saying, no, the agent did not have authority. We never gave authority to that agent. The third party will argue, well, even though you didn't give express authority to the agent was reasonable in believing that she had authority to bind the corporation to the contract with me, and therefore the corporation is bound. So if the agent reasonably believes she had authority to bind the corporation in this transaction, the corporation will be legally bound to that transaction. And the third party will argue this to make sure that the corporation abides by its obligations under this contract. So here are some examples. What would give an agent a reasonable belief that she had the power to bind, she had the authority to bind the corporation in this transaction? Well, maybe she did it in prior similar transactions. Maybe the agent has a particular job title and she reasonably believes that that job title gives her the authority to enter into this contract or transaction on behalf of the corporation. Maybe her general job description. She has a job description, and as she reads that job description, she reasonably believes that she has the authority to enter into this transaction. All right, finally, let's talk about apparent authority. Apparent authority might be the most important type of agent authority. This asks, did the third party reasonably believe, based on some sort of conduct by the principal, that the agent had authority. So this is a case where the agent does not have express authority, and the third party says, even though the agent did not have express authority, I reasonably believed that the agent could bind the corporation. I reasonably believed that the agent could act on behalf of the corporation. The business world runs on apparent authority. Think about any time you enter into a transaction with a corporation. The corporation doesn't sign the contract itself, right? There is some agent, some employee that is entering into this transaction on behalf of the corporation with you. Why do you think that that employee can bind the corporation? Well, you argue that you're reasonable in believing that that employee could bind the corporation. So here are some examples. Now remember, the reasonable belief of the third party has to be based on some conduct by the principal, but doesn't really require a lot. The law doesn't really require the principal to do too much. So in prior similar transactions, if I have dealt with the corporation before and this agent in prior similar transactions has bound the corporation to the contract with me, then I might be reasonable in believing that the agent had the authority to enter into this transaction with me. Just giving the agent a particular job title. So the corporation gives the agent a particular job title. That particular job title, the third party, when the third party looks at that job title, might be reasonable in believing that because of that job title, the agent can bind the corporation to a transaction with me. So for example, if I am dealing with the corporation's IT manager and I am going to sell computers to the corporation, I might be reasonable in believing that the IT manager can bind the corporation to a transaction with me to sell computers to the corporation. Let's talk about two other issues with respect to agent authority: ratification by the principal and inherent authority. Ratification is a pretty simple concept. Ratification happens where the agent did not have any type of authority to bind the principal. The agent did not have express, implied, or apparent authority. But for some reason, the principal ratifies the contract that the agent entered into on behalf of the principal. Now, the principal can do this expressly. So for example, imagine that one of the employees enters into a contract on behalf of the corporation, but the employee did not have express authority, implied authority, or apparent authority. The corporation might say, well, it's a good transaction for me, so I'm going to ratify it. I am going to be bound by this contract even though I am not legally required to do so. That's ratification, and that's express ratification. Express ratification can be oral or it can be written. The corporation might also implicitly ratify the contract. This is where they do not expressly say, I agree to be bound by this contract. This is where they perform under the contract. They know that they don't have to perform because the agent did not have authority, but they say, you know, this is a good transaction for us, let's just go through it. They don't expressly ratify it, but they go through with the transaction. So they perform under the contract, and more importantly, they accept performance from the other party. If they accept performance by the other party, knowing they didn't have to, and without objecting to it, then they have implicitly ratified the actions of the agent. Finally, let's talk about inherent authority. Inherent authority is this strange doctrine. It's an equitable doctrine where the court says, even though the agent did not have authority, the agent did not have express authority, the agent did not have implied authority, and the agent did not have apparent authority, we're going to hold the principal liable. The principal should be liable despite the fact that the agent had no authority to bind the principal. So typically, when does this happen? When does a court use the doctrine of inherent authority? Well, it's typical when the agent would have had apparent authority, right? The third party would have been reasonable in believing that the agent had authority, except the third party never knew there was a principal. When the third party was dealing with the agent, the third party thought the agent was the principal. The third party had no idea that the agent was acting on behalf of the principal. So when the agent entered into the contract, the third party had no idea of the existence of the principal. But, the court says, if the third party had known of the principal, then the third party would have been reasonable in believing that the agent had authority to bind the corporation or the principal in this transaction. Be careful. Inherent authority is not this. The act was inherent to her position in the corporation. If you say that an agent's authority is inherent to her position or her title with the corporation, what you're doing is you're setting up an argument for implied authority. The agent reasonably believed that she had the authority to enter into this transaction because this type of transaction, entering into this type of transaction, is inherent to her position with the corporation. Similarly, you could be setting up an apparent authority argument. Because of her position, because of the agent's position with the corporation, the third party was reasonable in believing that she had the authority to enter into this transaction. Why? Because entering into this transaction is the type of thing that is inherent to her position with the corporation. Once again, when we use that type of wording, inherent, that's just setting up an implied or apparent authority argument. It's not really setting up an inherent authority argument, which is strictly an equitable doctrine that will hold the principal liable even though the agent had no express, implied, or apparent authority.